All right, it's 12:31. Welcome to today's webinar. I am Tara Adamski. I'm the magistrate judge for the 6th Judicial Circuit and a member of the State Bar of South Dakota's Continuing Legal Education Committee. And before we get started with the webinar here today, I'm going to go over a few items so that you know how to participate in today's event. Do you or a lawyer, judge, or law student have a drug or alcohol problem, or struggle with depression or anxiety? Lawyers Concern for Lawyers is a confidential and independent resource for South Dakota lawyers, law students, and their families. Your referral or visit with Lawyers Concern for Lawyers is strictly confidential and privileged. Call Becky Porter for more information at 605-391-5191. Becky is an LCL member, and your communications with her are likewise confidential and privileged. South Dakota State Bar members and their families also have access to the Sand Creek Member Assistance Program, which includes a 24/7 hotline. To reach a trained professional at any hour for a confidential discussion and assessment, please call Sand Creek at 1-888-243-5744. Today's presentation will last approximately 1 hour. You will have the opportunity to submit text questions to today's presenter or presenters by typing your questions into the chat feature of Zoom. You may send your questions at any time during the presentation. We will collect and address them during the Q&A session at the end of today's presentation. I also want to say thank you to the State Bar of South Dakota and Continuing Legal Education, Inc. for their support of today's program. And now I'm going to introduce our presenters who have so kindly given of their time today. With us, we have USD Law Professor Tyler Moore. Tyler is an assistant professor at the University of South Dakota Knudson School of Law, where he teaches constitutional law, jurisprudence, and agricultural law, among other subjects. He is a native Nebraskan, earned his bachelor's degree from the University of Nebraska, his Juris Doctorate from Georgetown, and will receive his PhD from Notre Dame this January. Tyler practiced for 2 years as a litigation associate at what was then Faegre Baker Daniels in Des Moines, Iowa. He also clerked for U.S. District Judge John Gerard in Lincoln, Nebraska, and U.S. Court of Appeals Judge Jonathan Kobus in Sioux Falls. We also have with us Clay County State's Attorney Alexis Tracy. Alexis served as co-counsel hired by the South Dakota Senate to prosecute the impeachment trial against South Dakota Attorney General Jason Ravnsborg in 2022, or this year. Tracy has served as a prosecuting attorney since 2007 and as Clay County State's Attorney since 2016. Tracy has been an active member of the South Dakota State's Attorneys Association and currently serves as president of the association. Tracy has been a volunteer teacher for Junior Achievement Excellence through Ethics, served as a volunteer for the Judiciary Branch of South Dakota Girls State, and is a prior guest lecturer for the South Dakota Drafting and Legal Practice course at USD Law School. Attorney General Mark Vargo served as the Pennington County State's Attorney from 2013 to 2022. This past year, Mark agreed to serve as the impeachment prosecutor presenting to the South Dakota Senate on the articles of impeachment that were filed against South Dakota Attorney General Jason Ravnsborg. Following Ravnsborg's impeachment and debarment, Governor Kristi Noem asked Mark to serve as the Attorney General pending the investiture of an elected Attorney General in January of 2023. He was sworn in on June 28th, 2022. And in his copious free time, Mark has also been a coach for numerous youth sports organizations. He was also the coach of the Rapid City Stevens Speech and Debate Team for 7 years, earning him diamond status with the National Speech and Debate Association. And so with that, here are Professors Tyler Moore, State's Attorney Alexis Tracy, and Attorney General Mark Vargo for today's presentation. And I believe that we will start with Professor Moore.
All right, well, thanks, Judge. Good afternoon, all. Very pleased to be with you today. I want to thank Judge Adamski and Elizabeth Overmo for the invitation to join the panel today. I think we're going to have a great talk. As the judge mentioned, my name is Tyler Moore, and I do teach at our very own University of South Dakota Knudson School of Law. My wife and I both grew up in Nebraska originally, so not that far away. We love Vermilion. I grew up in a small town, so this already feels like home. Okay, well, today I'm here to talk to you about impeachment. And as a constitutional law professor, I take it my role is to kind of, canvass some of the basics of impeachment, talk about some of the current debates. And then I'll also have just a little bit at the end where I discuss the major differences between the South Dakota Constitution and the United States Constitution when it comes to impeachment. So let me see if I can share my screen here. All right. Are we good? All right, I see a thumbs up. Okay, so impeachment is, of course, the procedure we use in our federal and state governments for removing persons from office in the event of misconduct. So it's a key part of the checks and balances, between branches. So someone in the executive branch oversteps their authority, the legislative branch can kind of curb this by impeachment. Similarly with the judicial branch. And also, of course, protect citizens from abuses of power. So there are differences between the U.S. Constitution and the state constitutions, but usually the process is the same. So one house of the legislative branch starts the process and decides whether or not to charge the person at issue, and the second branch holds a trial and decides whether to convict. So I'm from Nebraska, I already mentioned, and we think we're special. We only have one house in our legislative branch, but even there are two votes. The first vote by a majority, whether to charge, and the second vote by a 2/3 majority to convict. So for the U.S. Constitution, this is all spelled out. First, in Article 1, Section 2, Clause 5, the House of Representatives shall have the sole power of impeachment. And then notice here, there's no, it actually kind of doesn't say whether there's a 2/3 requirement, which over time we've taken to mean that there's just a basic majority requirement. Article 1, Section 3, Clause 2, the Senate has the sole power to try all impeachments. We have the stuff about oath or affirmation, the Chief Justice sitting when the president is tried, and then here we have the 2/3 majority requirement for the Senate. Other clauses that matter here, Article 1, Section 3, Clause 7. This talks about the consequences of impeachment. So first, and again, my understanding is in merry old England, if you were impeached, you could be punished much more severely than this. But the founders thought, hey, it's good to limit this to just removal from office or the ability to hold office in the future. And we'll talk about that a little bit more. And then here we also have, that you could still be subject to trial, indictment. So after you're removed, the idea is that then you could be actually prosecuted for the crime or subject to a civil trial for it. Article 2, Section 4 tells us who can be impeached: the president, vice president, and all civil officers. Now you'll notice there's no judges on this list, which we'll talk about in a minute. And then the grounds for impeachment: treason, bribery, or other high crimes and misdemeanors. A few other scattered things: the president can reverse impeachments with the pardon power. So he can do a lot of things by pardoning people, but when you're impeached, you're impeached. Article 3, Section 1. So again, maybe I'll back up here to Article 2, Section 4, lists the president, vice president, all civil officers. So what about judges? There's no judges here. So Article 3, Section 1 actually tells us that judges hold office while in, quote, good behavior. So some people have wondered, well, is this the same standard, as this treason, bribery, and other high crimes and misdemeanors? Maybe this is different. Again, over time, practice in the U.S. has we've treated these the same. So judges can also be impeached, and they can also be impeached for the same categories that other officers can be impeached. And then finally, this is obvious, but Article 3, Section 2, Clause 3 tells us that there's no jury trial right for impeachment. The Senate is essentially the jury. You don't get, a separate jury than the Senate itself. Okay, so that's all the stuff you hopefully remembered before this talk, or I'm at least refreshing your recollection. So we actually do get a decent amount in the Constitution about impeachment. Again, the founders thought this is a core means for protecting people from governmental abuse. But it's worth noting there are quite a few gray areas here. What exactly constitutes a high crime or misdemeanor? Who is a civil officer? And one of the more important ones recently, what happens when an officer resigns? Can you impeach someone who no longer holds office? So we're going to get to these gray areas in a minute. But before we do, one other piece to the puzzle is something called the political question doctrine. Now, again, maybe this is something you have some recollection of from studying the bar or taking con law in law school. But the gist of this idea is that there's some issues the Constitution essentially grants to the political branches of government, such that the Supreme Court's not going to get involved. So if the president decides to use ground troops instead of the Air Force in a given conflict, for example, no one's going to be able to sue him and challenge this decision because the Constitution says, the president is the commander in chief. So the court, if someone were to challenge this decision, is going to say, look, the Constitution just gives this to the president. We don't get to, second guess this decision. And there are, a whole host of other questions that fall within this category. Now, I'm not going to take the time to go through this doctrine in detail, but okay, again, here, I just have definition when a question is non-justiciable because left to the discretion of other branches of government. So again, this is within the umbrella of things like standing, mootness, ripeness, or also justiciability doctrines. So I was going to talk about this case you may remember called Nixon versus United States in 1993. So this is a case about the other Nixon, a former district court judge who was convicted of making false statements to a grand jury and subsequently impeached. He challenged the process by which the Senate tried him. So essentially the Senate, I'm sure they were like, well, this guy's obviously guilty. So rather than waste our time, we're going to have a subcommittee actually hear the evidence against Nixon, and then kind of give that evidence to the full Senate later. Nixon argued, look, the text says the Senate, the whole Senate, shall have the sole power to trial impeachments, and I didn't get a trial in front of the full Senate. I just got a trial in front of a Senate subcommittee. But the court punted. The Supreme Court said, the Senate gets to decide for itself what it means to try someone. So we're not going to, Monday morning quarterback this decision. So why is this important in this context? Well, it's important because this is an area of the Constitution where we might actually go back and forth about what the right answer is and, look to, what the founders meant and have all these scholarly debates. But at the end of the day, it might actually not matter. It might really just matter who controls the Senate at the relevant time. And, it's just something that politics will decide, and again, we'll kind of come back to this here in a second. So let me say a few things about the gray areas here. So first, what is a high crime and misdemeanor? And let's see, second, can an officer be impeached if no longer in office? All right, so this first issue, what is a high crime and misdemeanor? This is, of course, the hot one back when President Clinton was charged but not convicted of impeachment. He had arguably perjured himself, but the question is, was this a high crime or misdemeanor? Now, if I was in class, I would ask you guys to kind of parse this out for me, but you might just kind of read this list and say, well, this just looks like a strange list. We've got treason, bribery, high crimes, and misdemeanors. One of these things is not like the other. Then this list is also, the phrase I think is also just strange in a different way. High crimes and misdemeanors, is it high crimes and high misdemeanors or high crimes and low misdemeanors? Just reading the phrase, it's a little ambiguous. So my understanding though is actually that this one is less gray than it first appears. And that the bulk of the evidence is that basically this should be read as high crimes and high misdemeanors. Apparently, here I went too fast there. Apparently, high crimes and misdemeanors was a term of art used kind of during the founding period that was meant to invoke other similar abuses of power, misapplication of funds, neglect of duty, corruption, things like that. But this was to be contrasted with simple maladministration, which was actually an additional ground of maladministration that was introduced to the Constitutional Convention and rejected. So the point, as I take it, is that you weren't supposed to be able to impeach the president or another officer simply because you didn't agree with his or her policy decisions. There really had to be some significant abuse of the public trust. That being said, I wonder if this is one that might well be a political question if it ever came before the court. Again, we've had 230 years of this Constitution. The court hasn't clarified yet what this means. And, you just imagine the context where these types of things would come before the Supreme Court. Imagine President Clinton had actually been convicted by the Senate. He challenges, whether perjury is a high crime or misdemeanor. Do you really think the Supreme Court's going to overturn the impeachment of a sitting president based on kind of parsing the meaning of high crime and misdemeanor? I doubt it. I think they would punt on that one. So this is one where I wonder if we'll ever actually get the Supreme Court to give us the answer. As to late impeachment, the second issue, again, late impeachment is the term we give for the question of whether you can impeach someone who's no longer in office. And here we move from Clinton to, of course, President Trump's trial. And here I actually think there are strong arguments on both sides. So on the one hand, the argument against allowing late impeachment, you'd go to text first and say, look, Article 2 says who can be impeached? The president, the vice president, and all civil officers of the United States. Nothing about ex-presidents, nothing about not holding office. These are the names of people that are holding office. So that's the first argument. Second is that there's a certain synergy if you don't allow late impeachment with the way kind of this sets up, where the two penalties for being impeached: removal from office, inability to hold future office. Say a sitting president commits a crime. Most people think, and also the DOJ apparently still thinks, that you can't charge a sitting president of a crime. So the way this works is you first remove him or her from office from impeachment, and then you can charge the president. So I guess this is another way of saying this is a big disincentive for the president to simply resign for the sake of resigning, because then he or she would open themselves up to criminal prosecution, and they'd be shielded from that if they didn't resign. Third, then, argument against allowing late impeachment would be, if you allow this, it's hard to know where to draw the line. So if you can impeach someone, 2 weeks after they've left office, what about 2 months? Or what about 2 years? And at some point, it becomes a little far-fetched, perhaps. But again, it's maybe also far-fetched, and that no one would really do it 2 years. I mean, the impetus to impeach someone would be pretty far gone, you'd think, at that time. Arguments in favor, the big one here is just the bad incentives. You essentially, if you could not impeach officers after they left office, what incentive would there be to ever sit through an impeachment? Instead, you just resign essentially once the votes you felt were against you. And apparently there are also English and state practice. So there was this really big deal impeachment of Warren Hastings, who was the president of the East India Company in Britain, right before the Constitutional Convention. He was no longer in office. There was another impeachment after the Civil War of an officer after he'd left office. But in none of these instances, and then obviously President Trump too, another one where the Senate actually held impeachment proceedings even though he was no longer in office. It's hard to know which way some of this practice evidence cuts, though, because the Senate has actually never impeached anyone. They just considered impeaching these people. So again, I think you could make arguments on both sides as far as the practice. The political question dimension of this, I think, is also difficult. But I actually wonder if this one would come out the other way. It's been quite a long time, and the Supreme Court hasn't told us yet. But I could imagine a situation where somebody is impeached a few weeks after they've left office. And this just seems to me more like a boundary question. Who can be impeached? Something that would be pretty clean cut, as opposed to, trying to construe what high crimes and misdemeanors is. Here it's either, they can be impeached or they can't be impeached. And so it wouldn't surprise me someday in the future if we get the answer. All right, a couple other comments about the South Dakota Constitution before I hand off the mic. So just wanted to know just a few of the basic differences. Here I've highlighted, so the requirement to impeach in South Dakota is all members elected rather than all members present in the US Constitution. And that's both for the House's decision to charge and then the Senate's decision to impeach or to convict. And then also the grounds for impeachment are interesting. And I think this is, if I ever wrote a paper on the South Dakota Constitution, it would be about this first one, drunkenness. I think it would be interesting to explore more where this came from. In the poking around I did for this talk, it seemed, I guess the first thing I hadn't realized was the connection between the temperance movement and women's suffrage. Apparently these two things were kind of both big deals in the 1880s and 90s and had some of the same interests on that side. Also, I learned that in 1873, the Senate did actually impeach, the US Senate did impeach a judge who had been drunk on the bench. And so maybe that some of this history played into, just kind of seeing the Senate had recently done this. Well, maybe let's put this in the Constitution. Otherwise, crimes, corrupt conduct, malfeasance or misdemeanor in office. These do just seem to me to be a lower bar than the US Constitution. Corrupt conduct is less, I think, than high crime, or especially if you kind of interpret that phrase as high crime and high misdemeanor. So maybe the historical context here again has something to do with kind of in the West we don't have, a lot of corruption, things like that. So this is kind of the genesis of that. So with that, I think that's my presentation, and I'll hand over the mic for more discussion of a recent impeachment in South Dakota. Thanks.
Thank you, Professor Moore. And I think we're doing a little bit of a town and gown here, because I feel like we're going to talk about you've talked about the theory, and we're going to get a little bit into the nuts and bolts of it. And if I'd known that I should have called you ahead of time, some of the theory might have been interesting going in, although it might have just been more of an impediment than of assistance. We can start off really with just the articles of impeachment, because the articles of impeachment themselves that were brought in this case did not necessarily direct us very specifically to what the case that the Senate should receive was. And so as Ms. Tracy and I started to look at this, we really wanted to decide how much we felt that we were bound by a variety of things. And obviously, we felt that we were bound by the language of the articles of impeachment. So for instance, the first article of impeachment very specifically referred to crimes that led to the death of Joe Beaver. And so we felt that that was absolutely a constraint on our ability to pursue any other form of crime that might have been committed. But then the second article was much broader in scope, and we basically, most of the presentation was permissible, we felt, under that second article. But there was a very interesting question that she and I went through, which is, are we really bound by the intent of the House? In other words, should we be looking at the House argument and the speeches that were, by the way, all in favor of impeachment? None of the people who voted against gave a speech as to why they were voting against the impeachment from the floor of the House. And we decided in the end that we were not necessarily bound by that, and that we really couldn't divine what the intent of the House was, because the intent of the House was the intent of the 36 members individually, and as far as forming a collective oneness, we weren't sure that we could get to that level. And so we really decided to be bound strictly by the articles themselves.
And so, piggybacking off of that, the articles, of course, guided us as far as what we needed to do. That's our charging documents and how to go about presenting the case. But another very important component in that regard was the rules, which were very different. So we're going into a trial with, we typically know what the rules are for us, rules of evidence, rules that our judges have for us in the courtroom. And now we have a whole new set of rules. And so I want to see if I can share my screen here. Let's see.
Notice I didn't even try.
I'll probably get it wrong though, Mark. So we'll see. So hopefully you all can see that. These can be found out on the Legislative Research Council website. It's under the archive section of things. And so actually, if you go out there and search, it's going to be this 2021 second special session, and there's a bunch of different tabs over here on the side. And if you search around long enough, you can find just about anything you're looking for. But specifically, there's the articles of impeachment. And then if I can find it, here are the rules. And so each time, it's one of those things where each time we read them, I felt like we saw something new in there, and really wrapping our mind around the timeline we were under and what did we need to accomplish within certain deadlines, which I think were really well thought out. I give President Pro Temp, Senator Schoenbeck credit, as well as the other members who worked on this, because they really put together some good guidelines for efficiency. It made it difficult at times, but it also contemplated giving us time to put together the case, get information to the senators, and then have time to go about presenting that. That was one of the other things that, and make sure all these procedural elements were met with the assistance of the Legislative Research Council, getting the Attorney General served. Obviously, everyone knew when that vote went through, but complying with those procedural aspects of things, going about what that process would look like, knowing that we needed to submit all of our documents ahead of time, though they weren't going to really turn us down for anything that wasn't, but it really helped facilitate for the senators to be prepared, because of course, the time constraints were significant. And when we look at that about what time the trial will start, each side having 1 hour to give an opening statement, and a total of 4 hours to present. And that means our case, saving any time, we would kind of have to guesstimate for cross-examining the other side's witnesses, because your 4 hours came out of the same time bank, both to present your own case and to cross-examine witnesses. And then, and the other side would then have 4 hours, and then each side would have an hour for closing arguments. And then we kind of rebounded into this mix of trial process and appellate process. And the appellate process really being one where then there was this opportunity for the senators to get to ask questions. And it really felt more like, a Supreme Court appellate process where they're getting to just ask you questions and not really knowing whether those questions are going to be directed to us or whether those questions are going to be directed to our witnesses. And as anybody who watched it got to see, it was a little bit of mix of both. And so it was a very fascinating process to then have this appellate process going in there. And actually I got it out of order. Then closing came after that questioning process. So it was interesting to prepare for that and try to ascertain what they were going to ask us and how to go about that. Also constraining, what do we need to put in front of them in that time frame that we have to work with? How much time should we save anticipating who witnesses for the other side might be, getting our subpoena requests into the Senate on time. Different in the 2/3 majority of a vote is a different process than, but way more jurors than one has ever anticipated in any other trial proceeding before. And other interesting avenues of things as we worked through that about what to present, what would they want to hear, and what did we need to draw their attention to, having shared all of the information with them ahead of time.
It was really, really fascinating not to have voir dire, for instance, because as we all know, we use voir dire to educate the jury on what's coming. There could not have been a process that was less like voir dire. The voters took care of that for us. They made the selection. But it was also a situation where every juror, so to speak, knew all about the case, or at least thought they did. And so the idea that we normally go through, where the rules are that if you know a lot about this case, or if you have a preconceived notion about what the outcome should be, that you're ineligible to serve on the jury, was completely turned on its head. And so the rules were, I thought, really well crafted, but it was absolutely kind of a stunner for a prosecutor to be walking in and just going, okay, we'll take the first 35. And somebody else just seat them, and we'll just talk to whoever you put in the room. Similarly, I have prosecuted in courtrooms before where jurors are permitted under different rules to submit questions of the witnesses. So I have been in jury trials where judges will allow the jurors to hand up written questions to the judge. And if the judge deems it appropriate, well, then the judge would then ask the question of the witness on behalf of the jury, which is always interesting when you have to object to one of those questions, but that's a whole different lecture. And then the 2/3 majority that Alexis mentioned is absolutely it's a burden. But she and I are mostly working with unanimous verdicts up till this point in our careers. So in some ways it felt like it was accessible. But the rules were a really fascinating process. Particularly, we had a lot of really good guidance from LRC. They told us what they could, and I think they shared this obviously with both sides. But they also warned us that the Senate sits as both judge and jury. And if the Senate chooses in the middle of the trial to change all of the rules, they absolutely could have done so at any time of their own choosing. And that's a little daunting in and of itself as well.
Yeah, that was really unnerving to know that we could go in there and everything we had prepared for, we just have to shift. Fortunately, they didn't do that to us. So really boiling down to those articles of impeachment and how we approach that from a strategy standpoint, and kind of going back to what Professor Moore said about what one can be impeached for, and looking at those articles and this concept of crimes, and in this case, misdemeanors that were articulated with specificity in the charging documents. And so that was one of the things that we struggled with. It was hard at times, and Mark will talk more about this too, but to abandon that prosecutor mindset completely, I couldn't do it. And I don't think he could either, but I really struggled with certain aspects of, the rules of evidence are just out the window. And so it was really hard for me. Also, and the gravity of this proceeding. I mean, this is a serious, serious proceeding. And so we didn't want to completely abandon all of that. So when we looked at the articles, and Article 1 in particular, were we bound by that language? So when I think of it in terms of a grand jury indictment, if I specify with specificity, the aggravated assault was committed, I don't have to, but if I'm gonna specify and drill down on the way it was punches to the face or something in that regard, now I've got to prove that specific aspect of it. And so accordingly, I think analyzing Article 1 similarly of the crimes that led to the death of Joe Beaver, and we all know what had been criminally charged. And so recognizing that these crimes that were specified, including, and some were listed within Article 1, were important, and we needed to address those, but these weren't just any ordinary misdemeanor crime. And recognizing that it was the manner in which these crimes were committed, the fact that a man lost his life. So speeding down the road, your average misdemeanor crime or offense is not going to necessarily result in someone getting impeached. Why are these ones important? And that's why they were brought forward. And really underscoring that was an important way that we analyzed the crimes leading to the death of Joe Beaver. And then, of course, the response and the aftermath of that. We felt was very important, that aggravated those circumstances. So yes, they were the crimes leading up to, it was the nature of the crimes that made them so horrendous. And that's what we tried to present evidence showing these crimes in particular are different than others.
And while you could certainly argue that other criminal acts had occurred at the same time, and Alexis and I decided that it was absolutely appropriate to stick to the ones that had been charged. And you'll notice that we did not address other potential crimes that could have been charged. And that was in part because I felt that that's what the House intended and what the language of Article 1 reflected. Obviously, there were senators on the floor who thought differently, and in their comments on the event, very clearly went to additional crimes that they felt had in fact been committed. But we tried to stay with those that had been charged. And we did distinguish that we felt that these were among the most serious of misdemeanors for the reasons that Alexis just said. Somebody lost their life. This was not a simple veering off of the road, but one where there was a significant period of time. This wasn't just like at the very edge of the road, but well off of the road. For all of the different reasons, we tried to show that it was a more aggravated form of misdemeanor warranting a more aggravated circumstance. But really, I think that very early on, we identified that the second article of impeachment was going to be crucial to the decision-making process of the Senate. And in that, they simply said other acts following the death of Joe Beaver, and they said that the Attorney General had failed to meet the standard of the office of Attorney General. So if the first one was significantly constrained in terms of its scope, this is about as open a charging document as you could possibly have. And again, we were presented with an opportunity to make some decisions about what our case needed to look like. We had no elements. So, I tell the baby prosecutors all the time, when you're charging a case out, you should look at the statute first and the jury instructions second, but both of those should happen before you're going to a grand jury. And we have no elements. There is, as Professor Moore pointed out, there cannot be case law on this. First of all, because South Dakota has never gotten to the point of an impeachment, but there isn't case law in other jurisdictions because of the political question doctrine. So we were left with looking around at other impeachment processes and trying to guess what maybe they were thinking. And about, I don't know, probably 2-3 weeks before trial, Alexis, we kind of abandoned that process. We just decided we were going to decide what these rules were. It sort of helped that at one point I pulled up a video of the impeachment expert that had sent the letter on behalf of Mr. Roundsberg to the House and who was listed as potentially one of his lawyers in the Senate. And in one of his podcasts, he brought on a guest who had opined that the standard of impeachment is whatever each senator wants it to be, and the crimes or the acts that can be impeached are whatever each senator wants it to be. And so we focused in on it much more like trial lawyers on what is going to convince this group of people to return a verdict of impeachment. Because we felt that that was the charge that was laid upon us by the Senate, that we were there to present the best case that we could. And that, again, I think that we have lingering prosecutorial mindsets. We like to think that we strike fair blows if we strike hard ones. And so we did definitely, I think, present a vigorous case. But what I will say here is that any time that you have in your possession, let's just say the phones of a person going back years, there is always something there that could be used that doesn't look good. Every single one of us, if we were on a camera every day, I think that there are things that you say things that are unfortunate. And we made a very conscious decision to leave all of that by the side of the road, that our focus was going to be on the crimes themselves and on the very specific response to those crimes.
Coming off of some of that, as far as the challenges, some of the other kind of unique challenges that I think we're faced here were some of those things of getting rid of typical mindsets of preparing for a trial, especially, as Mark indicated, as a prosecutor, and you look at your role and your job as a keeper of justice, and not just to get convictions on people, but really to present things in a fair fashion. And so all of those rules of evidence and things that we typically ground ourselves with, to not have those for these proceedings were difficult. And so, you know, we analyzed some of this along the lines of a defendant's right to remain silent. I mean, that's fundamental to things that we do. And so we analyzed, did, you know, former Attorney General Ronsburg have the right to remain silent in these proceedings? Was he going to choose to testify? And when it became apparent that he wasn't, you know, we pondered subpoenaing him as a witness. We made that request a day late, and so that subpoena did not go out, but had pondered that of, is that something that we could have done, should have done? Did he have the right to remain silent? And what are the implications of that? It was more convenient that his criminal case had been concluded, though arguably the you know, any false statements he had made would have been in another county, not the one where he was charged. So, you know, there was that component of that. Any uncharged offenses, could we comment on those? And I think that, you know, as we talked about here, I think the answer to that is probably yes, but that prosecutor mindset, it felt like more stable ground to focus on the ones that were specifically mentioned, though I think certainly the Senate could consider the others. Not having the rules of evidence. When we were prepping right up to the day beforehand, I remember I took a coffee break mid-afternoon because I was struggling so much with this concept of not having to lay proper foundation for an exhibit. It was difficult for me to let go of that. But under the time constraints that we were in and asked leading questions and all of these things, we had to do some of that. There's no way we could present this case in far less than 4 hours. I mean, we're reserving ourselves some time to cross-examine any witnesses they may call. And so you couldn't have been bound by the rules of evidence and get through that process in an effective fashion. And I think that was important for the time constraints and to bring some closure to this for our state and keep it moving forward. So I think all of that was well thought out, but it was definitely difficult. And then also understanding the prosecutor mindset, I think it was beneficial for the Senate to select us as prosecutors to try this case, partly because of the role the Attorney General is in. I mean, he is the chief prosecutor, chief law enforcement officer. And I think it was obvious probably in my delivery of things and Mark's as well, but it was offensive. I mean, I believe this man lied and he did a disservice to our community in the prosecutorial realm and wanted to restore some faith in the people and what we do. And so I think that was unique, but I think it was appropriate for us to be tasked with this task and analyze it, calling those things out from a prosecutor standpoint.
And that really led us into what we focused in on in terms of trial themes, which were obviously the underlying crimes, but then particularly a lack of candor and an attempt to use his position to extricate himself from the problems that he had created for himself. And I think Alexis is absolutely right. Our passion on this largely arose out of a sense of betrayal. I have known lots of prosecutors, and some are great and some are okay, but when there is one that does something wrong, it feels like it comes back to all of us. I think all of us as attorneys get those attorney jokes, and you cringe a little bit because that's not really fair, and but sure, there is somebody out there who acts like that. To me, in terms of prosecution, it even hits more closely to home and more closely to the core, because we occupy kind of a special position within, we have different rules in front of the tribunal. And as the chief law enforcement officer, the idea that you would be lying to law enforcement is pretty much unthinkable. And the idea that you would try to badge your way out, that was one of the interesting questions, and the lack of the rules of evidence. A fair amount of what we presented on that question was effectively 404B. And nobody decided that we could use 404B. We just said we're going to present it, and they're going to either accept it or reject it or say, no, that's not relevant. It has nothing to do with this case. But we honestly felt that it showed that what he said when he first called 911 and said, well, this is the Attorney General, that was not just a mistake or just a convenient phrase or a convenient way to introduce himself. It was a part of a pattern and it had a specific intent. And so we decided that we were going to make the decision on 404B. And if the Senate shut us down, if the other side objected, the president of the Senate would have had to make a decision about whether to allow us to proceed. But we felt that those two were the areas that spoke to the reason that this is unacceptable, and that our Senate set its own standard for impeachment. So the defense expert on the other side, Mr. Garber, who is absolutely probably the nationwide expert in the process of impeachment, basically said, yeah, there's just not enough here. But I think that both because we were dealing with South Dakota, which is allowed to set its own standard, and because we were dealing with the Attorney General and not another position, we felt that it was appropriate to focus in on those in terms of the acts following the death of Mr. Bieber. And so that's why we focused in where we did.
I think it's kind of the end of what, we've prepared for today or parsed out. If anybody has any specific questions for us, Professor Moore, about any of us, about what we presented on or the process, by all means, we'd be happy to answer any.
At this point in time, I don't think anybody has submitted any. I had one question that I don't know that the presentations have answered yet. What did you consider your burden of proof and where did that come from?
May I, Alexis?
Go for it. I know you want to answer this question.
So the burden of proof was another question that was raised on the same podcast that Mr. Garber was hosting. And the guest, who is sort of he's Mr. Garber's polar opposite. He's the guy that thinks a whole lot more people should be impeached. Mr. Garber basically believes he should have never impeached anybody. And he said that it is up to each individual senator to decide what that burden of proof is. But we were working with guidance from the Senate. The Senate did promulgate, the leadership of the Senate sent out a missive to the rest of the Senate saying that it's up to them to decide. Didn't specify a burden of proof, but if you read it and you're a lawyer and you're translating it back into legalese, I would have said that it was effectively a preponderance standard. Mr. Ravnsborg's attorneys tried to urge a clear and convincing standard, and it is obviously opaque to all of us as to whether any of the senators adopted that standard but felt it was met, or whether they rejected that standard and felt that some lower standard was met. So it's one of those things about the lack of review of this that makes it really interesting. We don't really know what they decided or what they were thinking. We just know what the final vote was.
One of the reasons that I think that the case that cases, but I know there was case law suggested in some of the materials that they sent out suggesting this clear and convincing standard, even under South Dakota codified law. And I would say I don't think that that's applicable, because those are dealing with statutory removal of office, not constitutional officers falling under the Constitution of South Dakota. It's not the same removal process. And so when we look at that, and we have officers that are removed statutorily, they have those other rights and remedies available. That's why there's case law about it and about what that standard is, because they don't have 2/3 of a Senate body who's going to have to come together and make that determination. And so I think that's why there's those different standards, and it's appropriate to be different in that context than it is when it's a constitutional officer and they've got to go through the House first, then get to the Senate. And like you said, we're kind of in jest, but truthfully, that many jurors, we don't get a voir dire process. And we do have to show 2/3 of the people in order to get, so I think it's just such a different process that I think the standard of deferring to the senators and not having that clear and convincing or clear cut standard is appropriate.
Professor Moore, any comments that you have concerning any of the presentations that you've heard or the concerning State's Attorney Tracy or Attorney General Vargo?
Well, this isn't really an informed comment, but it's just an off the cuff comment on the standard we were just talking about. I mean, I wonder, it does seem to me that, you know, here you're talking about, you know, with any standard, you know, if you're wrong and you convict someone of a crime and send them to jail, like that's a pretty big thing to be wrong about. In this case, if you're, you know, if it's a 51-50, you know, if you've got 2/3 of the Senate to agree that it's 51-50 that this person should be impeached, to me, you've already got the appearance of misconduct, especially even if there's not actual, you know, I mean, either way, it seems to me you'd want that balance to be in favor, I think, off the cuff of impeachment rather than, you know, keeping an officer that many people don't have confidence in anymore in office. Because again, the consequence isn't sending this person to prison, it's just they're not holding office. So I don't know, my off the cuff reaction to that.
Well, and part of our presentation revolved around the idea that there are consequences to the reverse. That if you do not remove that person, if you make it, you know, you set the artificial barrier, you set the higher barrier of either clear and convincing or theoretically beyond a reasonable doubt, that you can undercut the capacity of government to do its job. Because if people lose faith that the office holders are acting on their behalf, that has consequences all the way across government, which is exactly what impeachment is designed to remedy. So I do agree, and I tend to lean toward the idea that it should be a preponderance standard. But I also don't know how you impose a preponderance standard or a clear and convincing standard or a reasonable doubt standard on 35 jurors who receive no instructions and who are not law trained. Most of them not law trained, I should say.
The other, sorry, Judge, the other thought I had about this was back to this Nixon versus United States case. This is a case again involving this judge in the South who was convicted in the Senate by a subcommittee. So the majority of the court says, you know, this is a question we're not going to reach, non-justiciable. Justice Souter in dissent says, or actually, I think it's a concurrence. He would say, what the Senate did was okay, but I could imagine situations where what the Senate does is not okay. So he brings up the example, what if to get this guy convicted, the Senate just flips a coin. And if it lands heads, he's guilty, and tails, he's not. So I mean, I was thinking about this interaction in what the Attorney General and Ms. Tracy were saying, and that, you know, the Senate setting out some procedures, you know, whether to respect, you know, the right to remain silent, all these things seems to match more with the idea that there is some content to the word try, or there is something that, you know, that you need to do to have a trial. And that if it got, you know, to that point, then, you know, maybe the court would take it up. So that's a, you know, just something else to think about.
I would agree with Professor Moore. I think there might be a level of absurdity at which the court would feel they had to step in. I would imagine, though, there would have to be truly a level of absurdity. We actually joked about it ahead of time about the coin flip, but then each senator was going to flip a coin, and we had to win 2/3 of them. So, you know, we're behind the 8 ball already.
Well, does any of the presenters have anything further that they wish to share here today?
I just appreciate, thanks for having us. It was a very fascinating process to be a part of, and appreciate Mark's invitation to participate in the impeachment process itself. It was historic, but it was, you know, it's something that we hope we never have to do again. But I also felt really good with our senators about how they analyzed the evidence and thoughtfully considered everything, and walked away from that process being proud of our state for how everyone conducted themselves, and it was a good process, I think, in the end for us and for the people.
Here, here.
And I'll similarly say thanks for having me. Enjoyed, thinking more about impeachment to prep for this, and yeah, hope you all learned some things.
Well, I want to thank each and every one of you for the time that I know you put into presenting here today. I think it's an interesting topic, if nothing else, just for the stretching of the brain cells, and an interesting topic. So I do want to thank Professor Tyler Moore, State's Attorney Alexis Tracy, and Attorney General Mark Vargo for, and all of those that are in attendance here today for this topic. If anybody else who's in attendance has any additional questions, please feel free to contact the State Bar at info@sdbar.net. They can still direct those questions to the presenters. Once you leave today's webinar, you will receive a survey on the presentation, and we would appreciate if you complete that survey and provide your feedback. And on the, excuse me, on behalf of the State Bar of South Dakota, I want to thank you for joining us today. And I hope you have a great rest of the day and a great weekend. And it's awful drizzly here, so hopefully it isn't drizzly all weekend. So thank you.
Thank you, Judge.
Thanks all.